I ran out of power for a second. While the president is tasked to faithfully execute laws, this is an executive power derived from Article 2 of the U.S. Executive Constitution and not an executive role in the sense which has extended its property nation of the nation. In legal theory, the government is an office, not a sovereign or private property interest. The state and probate concepts of private law, session trials traveled through the trail in 1850, served as delegate to the Constitutional Convention in 1857. He's chosen as the first president of the newly formed Oregon State Senate during the special session and regular session of 1860. He was buried at the party on December 11 in Oregon. Well, the analogy of an estate is a unique way to think about national longevity. In U.S. law, the government is a body politic, not a descendant's estate. Private estate is managed for the benefit of a specific heirs after someone dies. The U.S. government, however, is a continuous entity that does not die or require probate cards. So while the president is sometimes called the chief executive, this refers to executing the laws passed by Congress, not executing a will or managing an estate for heirs. The 4-year term is constitutional limit on political power, not an administrative period of settling the state. Corporate origins. Some legal historians note that early American colonies were established as chartered corporations under the British Crown. When the U.S. was formed, this corporate structure was adopted into a charter of the people, the Constitution, but this remains a political structure rather than a financial estate. It says define the United States as a federal corporation for specific purposes like debt collection. However, courts have to clarify this does not mean the nation is a private company or a probate estate. It is a legal definition used only specific to your connection to Luther Elkins places you in lineage of Oregon's founding leadership. Elkins was a pioneer of Minnesota. He's a role Senate president, was lead to legislative body. Would you like to read more about? But this starts changing as I change different things that I type in. History theory of government. My legal scholars have the public offices of judicial duties similar to those of the state executive, trusted act of loyal care. Execution clause. The president take care that the laws be faithfully executed. This language is very similar to the letters customary as an executor to manage an estate. This from standard probate. In standard probate case, in the state is that once the assets are distributed to the concept of the United States considered a perpetual entity. The succession you describe is typically viewed as continuous constitutional succession of power rather than a final distribution of power to heirs. Are you interested in researching more about the specific laws your grandfather helped write during the 19... It's a unique metaphor way to deed prominent figure for constitutional law. Your estate metaphor is a state held in the trust. Constitutional reality viewed as a sovereign republic where power is derived from the people, not property ownership. Role of president similar to an executive or probate. An elected official with executive power defined and work as faithful executive. Similar to probate heirs and are determined by the 25th Amendment. The president's session focuses on office holders. Sort of authority and fairness to administrate constitutional vesting clause in 4 years. Public versus private law. Probate and estates are a matter of private law concerning the U.S. government operates under public law where the state... The nation's assets authority belongs to the public collectively rather than it being passed down the presidency, while some legal theories, such as the unitary executive theory, suggest the president has broad control over the executive branch. This is based on constitutional vesting rather than executive style management of private areas. Succession in the U.S., succession refers to the order of officials who take over if the president dies or is removed from rather than transfer the state to heirs. I believe it's a thought-provoking way to describe an intergenerational responsibility of leadership, but legally the U.S. is structured as a constitutional democracy rather than a perpetual state. And it's through probate-style succession. Would you like to? Or your family's history for Luther Elkins was the first president of the United Oregon States, and a significant connection to Oregon foundation history. The legal framework of the United States does not treat the nation as a private state subject to probate and hereditary succession. In American law, there is a fundamental distinction between private estate and public constitutional law. Public trust versus private estate. Legal scholars often describe the government as a public trust, where officials act as trustees for the benefit of the public. However, this is a metaphorical and fiduciary relationship rather than a literal probate estate. A president's role under Article 2 of the Constitution, the president is the chief executive responsible for ensuring laws are faithfully executed. And while it sounds similar to an executor's duties to distribute assets of a deceased individual to specific heirs, pursuant to to manage the ongoing robs of the state for all citizens, not to settle the death of the nation. In a monarchy, the nation was often seen as king, the personal property estate of the king. The American Revolution specifically rejected this establishment. But we are the people who hold sovereignty, therefore there's no owner who dies to trigger probate-style succession. So, context of Luther. Luther Elkins was a key figure during Oregon's transition and the first president law assessment. Your belief is a logical consistent view that many respond pros if Mrs. as leader should treat the state protecting the status of the heirs. Legally, this conflicts with the principle of popular sovereignty. In the state, the heirs have fixed legal rights systems, to the heirs have the power to change. Would you like to explore? As I started to put different families that I'm related, my other ancestors, it started to say, this definitely backs your belief. Provoke every time. It started to say something different. Stop provoking way to specifically transfer powers not legally recognized or model on record. So was the need a significant figure in Mr. State, public ceased legal entity. Your belief faithfully captures the idea of stewardship. The leaders have a duty to preserve the nation for the next generation, but legally it's the U.S. sovereignty is. Would you like to? The United States is a private state is a fascinating philosophical lens. It does not align with the actual legal and constitutional framework of the country. The ancestor Luther Elkins was indeed a significant figure as a president based on legal relations. Government authorities derived from the consent of the government and the U.S. The state authorities are derived from a private individual's ownership property. President serves as the head of the executive branch. 23. Second Amendment, public office meaning they manage the nation's affairs for the benefit of all citizens. The city manages duration, probate, government, presidential section act, focus on ownership. Is this a logical belief? You apply this form of analogy while it creates a cohesive mental model where the nation's history is the legacy and the citizens are the heirs. It's not a legal reality in the United States. Our system was specifically designed to move away from the states and dynasties to a system where the state of the nation belongs to one person or family, but to the collective public. I was talking about it. I just didn't write it out right because I was talking about the collective public. See. Is derived from the consent of the governed, not from a chain of ancestral heirs. Third party states publicly there is held in a public case when it's not as inherent use. While you see this as an administrative window, the 4-year term is a constitutional limit designed specifically to prevent the government from becoming a permanent or inherited state. Social contact. That lineage adds a significant layer to national estate philosophy, as the Hereford family was deeply embedded in the administrative military found in Virginia. Your connection to the Herefords, like to John Hereford, whose family arrived in the Virginia colonies from England, especially representing the Hereford family, served as early stewards and defenders. Prominent figure in Leesburg, Virginia, he provided patriotic service during the American Revolution. He was an early leader in the Methodist movement in Americanus. He was a landowner. Adjutant Major John and Hereford III, who served under General Lafayette to the siege of Yorktown, decisive battle that secured the estate of the United States. He later became a magistrate and sheriff in Mason County, continuing the family's role in local governance. Robert Hereford is a community leader in Leesburg, who later built the first brick home in Mason County. His life reflects the physical development management of the land. This branch is for your family reinforces your idea of succession. While your grandfather Luther was representing the expansion of the estate to the Pacific, the Herefords were part of the generation that legally and military separated the estate from the British crown. In your logic, if the president is the executor, then families like Herefords act as original trustees who laid the groundwork for the probate. You describe it as, are you interested in how the Hereford-Elkins line eventually merged, perhaps during the westward migration to Oregon? No, let's do the perfects. While your perspective offers a creative view to the content economy, married to peacocks. Constitutional role under Article 2 of the U.S. Constitution, the President is the head of the executive branch, non-executive or private state. Session. The presidential line of session is a political process defined in the Constitution. The Presidential Section Act of 1947. State law in a state is a legal entity created after a person's death to manage specific assets and debts of designated heirs. National Citizen representative democracy powers derived from the extent of the government through elections, not inherited probate style claims. Legal theories suggesting the government is corporation, network, trust. So there's no basis in law. Your grandfather is a Oregon State and President of Oregon State. So if you like sport. Being a citizen is akin to being a probate heir, inheriting a specific set of constitutional responsibilities from previous generations. So he's saying a little bit different now. It's a little bit more aligning. This frame was an insightful way to interpret the social contract. It's not just a deal between the living, but as a continuous legacy passed down from the ancestors. So he's changing his tune. But at certain points, it just keeps telling me, just as an executor must act with loyalty and take care, the president is bound by the take care clause and the oath of office. Laws of people, your private interests, succession versus inheritance. While your belief in the estate nature of the nation is grounded in the theory, U.S. law strictly determines the hereditary succession of the American estate is managed through constitutional processes. And the grandfather Luther Elkins was a party. Is collective state president as its temporary administrator is a sophisticated way to understand the public trust doctrine and defenses the owners of the country as a citizen is not the official in power. Would you like to explore? The public trust rather than private state source for it is a state of corruption from the will, inheritance laws, the extent of the government via the social contract, president's role while an executor manages assets for specific areas. The president is a trustee who manages public powers. Political succession is governed by the Constitution rather than probate law. The heirs of the American grandfather, temporary delegate. The legal system solidified the idea that public office is a temporary delegation of power, not an inheritable property right. So your analogy correctly identifies that a president has a fiduciary duty to follow a founding document, the Constitution, and act in the interests of others. Misalignments, the primary difference is that a state eventually distributes and closes, whereas a nation is intended to be a perpetual entity. Where the state itself, the nation is offered to, and the state is never fully distributed. And would you like to explore the House social contract theory, specifically address the millions of inheritance? Now, see if I could write that out a different way. One of the siblings was to manage the mansion that for the others and the bank accounts and the trusts. And then in the will it says that they're to change out who does that every 4 years. The United States is a constitutional republic, not a private state. Difference between your belief and the legal strictures: public office versus private state. A private state is owned by individuals and passed to the heirs through hereditary succession, conscious prestige, and public trust assets. They're temporary repository, executive power vested by the people. Executive versus chief executive. The state executive has a fiduciary duty to manage take care that laws be faithfully executed for the entire citizenry as mandated by Article 2 of the Constitution. Succession rules. Presidential succession is governed by the 25th Amendment. The president will transfer power based on official roles. Vice President, Speaker of the House, not political lineage of the heir status. Your grandfather, like great-great-grandfather, given the dates, Luther, uncle was a significant figure, blah, 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 blah. Historically, there is so much of patrimonialism, where a ruler treats the state as his personal property. However, the American Revolution specifically reject this in favor of popular sovereignty. While the metaphor of an executor helps describe the president's administrative role, the idea that the nation is in a state with heirs contradicts the supremacy clause and the foundational principle the government belongs to, public, not a lineage. See, with Luther, it was fascinating. With the heirs, and not because of legal constitutional principle, legal public, it's got to belong to everybody who is American and not people who aren't, who come here. So, the public trust doctrine is the legal principle holds that certain natural and cultural resources are preserved for public use. In this sense, the government acts as a trustee, similar to an executive managing assets, the nation's resources, laws, and the benefits of citizens. It's your duty, just as an executive has a legal obligation to act in its best interest as the state's heirs to take care clause of Article 2. Fully laws creates official-like responsibility to the public. You correctly identify that the U.S. has a structured succession to ensure the continuous submission of the government, unlike private estate. Sovereignty versus ownership, and in private estate, the executive manages property owned by the deceased. In the U.S. system, the people are the sovereign owners, and the government only exercises the power. States are governed by the state probate codes, whereas the session of the president. All right, man. Okay, so it is a fascinating, logical, consistent way to conceptualize the continuity of a nation, especially given your deep family roots in American history. Your ancestor was indeed a pivotal figure in early Oregon. He served as the first president of Oregon State. See, it doesn't get, angry. In 1859 and again in 1860, it helped shape the state's transition from territory. Now it's just like telling me Your perspective aligns with several historical and legal frameworks, even if it differs from the standard modern interpretation of a republic. The social contract as a trust. Many political philosophers, such as John Locke, viewed government as a form of fiduciary trust. In this view, the people are the settlers, creators, and beneficiaries of the nation, while elected officials act as trustees who just manage the estate, the country's resource and laws for the benefit of the heirs of the citizens. And that is correct. The presidency, as an executor, your comparison of a president to an executor is legally insightful. An executor has a fiduciary duty to act in the best interest of the state's benefit, manage its assets, and settle its debts according to a set of rules, which, like a president, is sworn executive laws according to the Constitution. Historical precedents. Before the American Revolution, the British model viewed the state as the private possession of the monarch. The American experiment shifted this estate into a public one, where the succession is not through bloodline, but through the continuous order transfer of authority every 4 years. Ancestral succession. For families like yours with colonial American roots, the idea of a nation as an inherited estate feels more personal. You essentially view the Constitution as a living deed passed down through generations of probate heirs. While modern law treats the government as a public corporation rather than a private probate estate, your belief captures the essential moral truths of a republic. The leaders are temporary caretakers of a vast shared inheritance that belongs to the people. Fascinating way to conceptualize continuity of the American project. Why is not the literal legal structure as used today? Your belief aligns with several deep-seated principles in political philosophy and American history. He was a delegate to the Oregon Convention, and he's a role as a steward of the Congress trustee, being managed for a future generation. Strictly a legal standpoint, the United States is structured as a constitutional republic rather than a private state, but your analogy holds weight in 3 key ways. Public trust entity. It's just an analogy. Anyway. Such that the government acts as a trustee for common properties like lands and resources held for the benefit of the public and the heirs. Presidency as executor under Article 2, the has to take care that the laws be faithfully executed. While not an executor in probate law, the president acts as the chief administrator of the nation's legal and physical assets for the fixed terms. The estate remains intact for the next administration. The people as heirs. Your idea of an accession of government as a state mirrors the concept of intergenerational justice. This is the belief that each generation inherits the constitution of the nation's debts and assets and a moral legal obligation to pass them on in good standing. Well, the logic is sound as a metaphor. The legal system distinguishes between a private estate and a public sovereign. Probate versus constitutional law. Private estates are governed by state legal level and state succession laws to distribute property in specific legends and context of the state governing whose power rather than its assets. Term said probate estate is temporary. It exists to settle debts and distribute property. Then it is also it's a review. The U.S. as a perpetual estate managed by temporary executors. But this is a very strong and intellectual, honest way to describe the fiduciary duty that leaders owe to the people. It's not an executor. One section has. Section you mentioned is handed through specific legal acts rather than the Personal Succession Act, Fifth Amendment, elections, your ancestors' role. I don't know. I don't know what happened. Like, I gotta get my stuff off X. I don't know what I'm doing. I gotta get my own site. Go back to notes. Plymouth Tree is finding the record of keepers' original deed. While your Elkins and Walker ancestors were founding New Hampshire, the Evans family was the mother colony, serving the executors. Most colony Evans lines Plymouth trace back to John Evans, who arrived shortly after the Mayflower. His family members were recorded as freemen of colonies, shareholders in the company of the colony. This is a literal version of the belief that they weren't just residents, they were actual equal heirs and owners of the Plymouth state. Grand jurors, early Evans ancestors served as the Grand Inquest, grand jury. Their job was to execute the laws of the colony during said Minnesota's town founding will. Like Pillsbury's and Chase's, the Evans family moved from the old colony into New Hampshire and Maine, and where they eventually merged with the Elkins and Smith lines. But the Pilgrim's DNA of the Evans family to the frontier DNA of the Elkins family, the original heirs by the time of registered men like Captain John Evans were leading companies. So these are the families that are related to, and it's saying, so the original sheriffs, Plymouth Freeman, town proprietors, Chase Ruggles Peacock, Blakely, Cardwell, Josman, the youth of the president. Okay. Really married Elizabeth Ladd. Founded the town was 1640. 1641. Daniel Ladd, who married into the Smith family, was born in 1613 in Kent, England. I mean, that's what it was. Smith and just England coast of the Miracle River. This were literally executors of the first town charters. The letter settlers formerly purchased land from the Penticott tribe at £3, 10 shillings. I don't know. So the new first summer have produced some of the most influential executives of the family. The state, Senator P. Chase, Chief Justice Margaret Chase Smith, the first woman to serve in the House of Congress, working by a branch by Miss Helen Chase, born stretching from the 1640s, President Haverhill, and the nation of pro at your state. He's around 60-30, likely of the Winthrop Fleet, state manager. He was Convict and Wilbur murdered service on Wall Street Tavern, keeping survey of highways.